The broadcast has started. We continue our meeting. We are discussing Lytvynko Tetiana Volodymyrenko, her compliance with the criteria according to the law and the High Anti-Corruption Court. Please invite the candidate to the room. Good afternoon. Tetiana, we are to discuss the possibility of compliance of Tetiana Lytvynko with the criteria according to Article 8 of the Law of Ukraine, the High Anti-Corruption Court. Here we have the Public Council of International Expert members, Gabriel Yudkai-Tigrotsky, Norman Haas, Robert Heiss-Brookhuizen, Jessica Thompson, John J. O'Sullivan, members of the High Qualification Commission of Ukraine, names of the Commission members. Your rights are, you can demand that a member of the Commission is recused. You can provide your comments with permission of the chairman. You can make your comments. You can appeal the decisions. At the special meeting, we're not discussing any new material submitted by the candidate if the candidate had a possibility to submit them before. If there are any circumstances that can significantly affect the decision on the initiative of at least 3 members of the Commission or the PCIE can decide that additional documents can be joined to the previously submitted documents. Would you have any request for recusal? No, the microphone is off. Yes, you need to press the button for the microphone to work. A member of the Commission, Roman Kadasiuk, is the spokesperson. Good afternoon, Tetiana. Good afternoon once again, everybody. So, here's a brief report about Judge Tetiana Lytvynko, judge of Shostka City District Court of Sumy region. Before I start, Tetiana, let me tell you in general now that you're going to receive questions about at this meeting related to integrity, some issues related to professional ethics. So you're ready to answer the questions. Is that right? Yes. Good. Let's start. Tetiana Lytvynko, judge of Shostka City District Court, Sumy Oblast, born in Zhytomyr region. She has high legal education. She received a high university degree in the profession of law. She's the Master of Law. After all the necessary procedures according to the law, according to the executive order of the President of 2016, Tetiana Lytvynko was appointed a judge in Shostka City Court of Sumy Oblast for 5 years. At the same time, I want to say that the working activities of Tetiana before she was appointed judge, she also worked within the judicial system, in particular at the Court of Appeal of the city of Kyiv. In particular, her first position was chief advisor of department and head of department, later assistant judge in the Department of the Judicial Chamber Support. She also had the positions of the judge of the President of the Court, the Department of Documental Support. Then she was appointed to the position of the assistant to the chief or deputy chief of staff. In terms of her participation in the competition, Tetiana has submitted her documents for the competition to the Court of Appeals. The competition was cancelled in 2023. At the same time, a new competition was announced where Tetiana is also participating. As a result of her test in the general knowledge of law in criminal cases, she has received 149 points out of 150. As regards the competition to the High Anti-Corruption Court, her results of the tests are as follows. As a result of the tests, she has received 147 points out of 150. In terms of her cognitive skills, she has received 123 points out of 140. And as a result of her practical exercise, she has received 120 points. Besides, as regards her professional career, not a single time the judge has been taken to disciplinary account. That's the end of my brief report, and I'm giving the floor over to the chief of the PCIE, Mr. Robert.
Thank you, Mr. Chairman. I would like to pass the floor to my dear colleague, John O'Sullivan, who is the rapporteur in this case.
Thank you, Robert. And good morning or good afternoon, Judge Lytvynko. Is it okay to call you Tetiana?
Добрий день.
Yes?
Звичайно.
Definitely. Please do.
Okay. I'm going to introduce you to my colleagues first who are sitting to the left of me. All the way at the end is, I'm going to use their first names, is Norman, who's a lawyer from Estonia. And sitting next to Norman is Gabrielle, who is a Supreme Court judge for the country of Lithuania. And then we have Robert, our esteemed chairperson, who is a lawyer from the Netherlands. And my friend Jessica, a lawyer from Canada. And I am a retired judge from the United States, from Miami, Florida. You can call me John, and I'll call you Tetiana. So first, let me congratulate you for getting this far in this competition. This is a very competitive selection process. And it's a privilege for me to have the opportunity to participate in it and to have been appointed by the HQCJ to assist them in selecting qualified judges for the High Anti-Corruption Court. There's 4 areas I'm going to ask you about, and then my colleague from the HQCJ is going to inquire in some other areas. The first area I'm going to inquire about is your motivation to be a judge in the High Anti-Corruption Court. The second I'm going to ask you of is a complaint that was filed against you in October and November of 2019 that I understand was not sustained, but I'd like to get some facts regarding that. The third area is the accuracy of your disclosure reports. And finally, the last area is information regarding an apartment that was purchased by your mother in Kyiv in 2015. So why don't you tell us why it is you want to be a judge of the High Anti-Corruption Court? And we have a rule we've been following here, three minutes at the most for your response to questions, if you don't mind, so we make sure we can get all our areas addressed. Thank you.
My main motivation is my professional development, career growth, and of course, my desire to improve not only myself, but to participate in the processes that affect the development of my country by administering justice. For me, that's the best way to influence the processes taking place in the country. That's it.
Why do you believe you are qualified to be a
Sir, your microphone, please, your microphone.
I'm sorry. Why do you believe that you're qualified to be a judge on the High Anti-Corruption Court?
Well, of course, I cannot insist, but I have some experience as a judge. I'm interested in studying criminal law, criminal processes primarily. I understand my level of knowledge, including with account of my communication with my colleagues and other legal experts who also assess my knowledge and who say that it is quite high in order to try to work at this court.
Have you addressed criminal cases as a judge in the Shatska region?
Definitely, I've heard many criminal cases with many decisions and judgments that I've rendered.
And how about corruption cases?
No, unfortunately, in this area, I have little experience. That is true. Mostly these were cases in administrative, corruptive-related violations. I've had about 6 criminal cases in terms of corruption-related cases, but I did not complete them because my competence was over at that time, and in fact I have only 1 criminal case where I have rendered a decision, but I keep studying the case law of the Supreme Court, of the High Anti-Corruption Court, the Court of Appeal in terms of such cases, and that's how I try to gain more knowledge. Well, I don't have any other way for now.
It's my understanding that you're actually applying for 2 positions at the same time, the position on the High Anti-Corruption Court, as well as a position as an appellate court judge. Which of these 2 positions do you prefer?
Well, I definitely would prefer this competition if I can win it.
Why is that?
I believe that the judges in this court are some of the most professional legal experts and judges in this country. Second, I see how the society treats this court, and this attitude, public attitude, is much better. The trust of this court is much higher, and I think that it's the judges who are to thank for that, and I would like to be a part of this process of bringing back the trust of the society to the judiciary. It's not about making my life pleasant, but it's about the essence of my life, professional life, I mean.
So let's move to there was a complaint that was filed in October and November. I think it was filed twice, but it was essentially the same complaint by a gentleman named Vasil Nikiforets. I may be butchering that name, but I think you probably know who I'm talking about. Can you tell us what the substance of the complaint was and what happened with the case?
Well, in fact, I don't even understand what the purpose of that complaint was. That person complained about violation of his honor and dignity by the mayor of the city. I heard the case, I rendered a decision with which I found that there was a violation of his dignity, of that person, by the city mayor, and in fact I awarded moral damages to him. But the plaintiff was not satisfied with the amount of the damages, and he filed a complaint saying that it had taken me too long to hear the case, but he never appealed. I don't really understand what his motivation was. Unfortunately, I didn't know we were going to discuss that complaint. But the plaintiff even wrote me letters where he said that I was a very good judge, that he had good attitude toward me. Why he complained about the length of proceedings, I don't know. But then the circumstances were quite objective because we had very few judges in that court at that time, 3 out of 11 together with me. And that case, came to us because Krolevetsky district court could not hear it. It was a neighboring court which had only one judge who could not hear that case. And I heard that case, in a very quick period of time, as much as possible, so I don't really understand his reasons for filing that complaint.
Was there any ruling on the complaint? Whether it was justified or not?
Я взагалі не бачила жодних документів за
I
результатами.
never saw any documents as a result, of working with that client. I only was given a possibility to provide comments. I did that, and while I could not have heard the case within 2 months, and there were no other documents I ever received from any authority, so I know nothing about that. I could only see in my file which said the results of the hearing, no results, and that's all the information that I have.
So the next area I'd like to move on to is your annual declarations. And I understand that from 2015 to 2023, you reported your interest in a residential building in the village of Paskivka that you had with your parents. Is that correct?
Yes.
And from 2015 to 2022, you didn't report the land plot that was located under the house. But in 2023, you reported it for the first time. Tell us why you didn't report the land plot prior to 2023.
Well, I've already tried to explain that. I'm a co-owner of the house in that village of Pashtkivka. It was privatized by my parents when I was very young. And that building is really located on a plot of land. The right of property is with my father, single-handedly. Therefore, starting 2003, I have not lived with my parents. I have not used that house or the plot of land. And as I believed that as I was not the factual user of that plot of land and I was not a co-owner of it, that's why I never declared it. At the same time, while studying the issue of violations or kinds of breaches of the declarations, especially as I looked at all kinds of conversation with the High Qualification Commission of Judges, I saw that it was quite a widespread mistake when plots of land were not declared. I realized that it was a mistake on my part, and I started declaring that plot of land as the plot of land that was under the building and was part and parcel of it.
Let me ask you about a second issue that came up on the declaration. It's my understanding that in 2015, you were working in Kyiv. You were living in an apartment, and that was not reported on your disclosure report. Tell us why that was not reported.
This was my very first disclosure form submitted electronically. I wasn't a judge. I was working for the court staff of the appellate court, so I only declared my co-ownership in a house. As for the apartment, since I was using a room and didn't have any documents in writing On the lease of this room, I felt I couldn't even declare the properties since I don't have the data about this property nor the title to this property, and I thought I did not need to declare. It was certainly a mistake on my part. I don't quite remember what I was thinking back in 2015, why I felt that way. I know this is absolutely wrong, but there's nothing more I can say apart that it was a mistake. I did provide the information about my place of residence because I provided a similar declaration, only paper-based, at my place of employment. I have it. I've sent a copy, and I stated the apartment where I was staying, and I was leasing one room in it. This is all I can explain to this effect. It is correct.
I'm happy to hear you admit your mistake, and I'm sure it won't happen again. So let's go to the fourth area, your mother's apartment in Kiev. It's my understanding that in November of 2015, she purchased a 45.7 square meter apartment in Kiev. Is that correct?
Так, майнові права, як такої квартири ще тоді не було.
She did not have the property rights then. It was still in the process of construction, but it was planned to be constructed as such apartment that you had described.
And your mother was a math teacher and school principal. Is that correct?
This is right.
And my understanding is that the purchase price was 548,400 in Ukraine currency, or approximately 23,000 US dollars. Is that correct?
Yes, this is correct.
And almost all of that was paid on in January of 2015, with the exception of 2,160 Ukraine currency that was paid the following year. Is that correct?
Yes.
I also understand that your parents, from the review of tax records, earned together between 2000 and 2014 approximately 47,000 US dollars. Does that sound about right to you?
Так, приблизно так. Це мається
Yes,
на увазі
this is roughly so.
саме заробіток із
This was the earning
роботи в школі.
from working in a school, the school payroll, but this was not the income from their homestead, from their individual agricultural operation.
Tell us about the agriculture operation. What type of operation was it? Who performed it, and approximately how much income was earned from that?
Сільськогосподарською діяльністю можна розподілити на дві частини.
We can say there are two elements to the agricultural operation. One was breeding cattle. My parents had 10 to 13 heads of pigs that they raised a year, and also they tilled the land, which was issued to my father and mother as their stake in privatization when the former collective farm land was distributed, if that makes sense, I hope. After the dissolution of the collective farms, the assets belonging to the collective farm was allocated amongst the members of the collective farm free of charge. So my father received 7 hectares of land. He was a co-owner of agricultural tilling machine, and as far as I know, some other assets like a cultivator, a plow, and that's all to my knowledge. He grew cereal crops, wheat, spring wheat, barley, and sunflower. He tilled the land himself on his own, and then he spent some harvest to feed the pigs, and some was put to sale to generate proceeds. As my parents had explained, they never kept any records, but I can say that I could witness some of the operations with my own eyes. I could see them selling their produce. Some people would come who buy either crops or livestock products in bulk, and they buy up the available produce from the producers. The parents could not provide any documents. They said that the profits they had generated did not call for the taxes, so they did not receive the documents from the people buying up their produce. Surely, when I received the question, I started looking into the question of taxation of individual agricultural operations, and the regulation of this matter wasn't entirely clear. The farmers were exempt from paying taxes for the crops and livestock production if they grew it within their own household farm, if they did not hire any extra hands. And then the legislation had changed, and the farmers could get an exemption only for a certain income level, and that gave them a tax waiver. The parents were not able to give me the level of their income by the year, and I naturally don't have the information either.
When your parents purchased the apartment, was it finished, or did they have to expend funds to finish the apartment interior?
In 2015, the house wasn't fully erected and the apartment did not exist. As such, we received access to the apartment on the 14th of December 2016 when my mom got the completion of work certificate. The apartment wasn't finished, wasn't furbished, it had nothing in it, and for a time it stayed that way. Then my parents, with their remaining savings, started doing the renovations. That took them several years to complete, but I cannot give you any specific dates. I asked the date when the tenants are staying that I had reported, and they told me the date, and I don't have any other records.
I believe in your response to our question, you estimated that they spent another approximately $7,000 to finish the apartment.
This is at least so. They bought the main materials with the money, and then there's some furniture, and some of it was bought from the lease proceeds, such as the TV, a small closet. People had been living without these items, but they were paying rent to my mother, and she bought some items to put in the apartment. So 7,000 is the minimum, but I cannot tell you any more specifically than that.
Are there currently tenants living in the apartment?
The same people are still staying.
Do you have any ownership in the apartment?
No, I do not.
Do you receive any proceeds from the apartment?
Ні, абсолютно. Всі кошти
No,
надходять
absolutely.
моїй мамі.
My
У
mom
них з батьком
receives all the
невеликі
proceeds.
пенсії.
Their
Наприклад, у
pensions
мого
are
батька
small. My
$60
father
пенсія. І
has
це
a
єдине,
pension
що
of
допомагає
$60,
їм
and this is what
жити
the only thing that
нормально,
keeps
більш-менш.
them and helps them make ends meet normally.
Thank you, Tetiana. I don't have any further questions at this point in time. I don't know if my colleagues would like to inquire at all.
Oh, thank you, John. Please I give the floor back to the chairman of the Qualification Commission of Judges.
Дякую, пане Роберте. Колеги, чи
Thank you,
будуть питання
Robert.
до
Colleagues,
кандидата?
do you have any questions for the candidate? Over to you.
Дякую, пані Тетяна, за вичерпні
Tetiana,
відповіді.
thank you for your exhaustive answers that you had provided, but I would still like to pose a number of questions.
В місто, де
If I may bring you
по питаннях,
back
де ви знаходитесь, де ви здійснюєте правосуддя.
to the
Скажіть, будь
city
ласка,
where you administer
скільки на
justice.
даний час
If
у
you would
Шосткінському
tell us,
суді діючих суддів, які
in
здійснюють правосуддя. І
Shostka
тоді,
Municipal
ще відповіді
District
зразу
Court,
задаю
how
питання
many
стосовно
judges
тих
are
суддів,
sitting
коли ви прийшли,
on
скільки було
cases, and
діючих
also
суддів,
how
які
many
здійснювали
sitting
правосуддя?
judges were there in this court when you joined the court?
Я розпочну з останнього.
If I
Я
may
все
start
ще не
with the
пам'ятаю, ну,
last
здається,
part of
8
your
було,
question,
коли я
if I
прийшла.
remember
Мабуть, я
correctly, there
точно не
were 8
пам'ятаю.
or
На сьогоднішній
9
день це 4.
judges. Currently, there are 4.
Скажіть, будь ласка, а що особисто
Tell
для
us,
вас означає
please,
адміністративна посада в суді?
what does an administrative position with the court mean for you?
Особисто для мене вона
Personally,
означає
for
додаткову
me, it
відповідальність,
means an
додаткову
additional
зайнятість,
responsibility, additional workload,
але і можливість
but
виправити
also
певні
an
процеси,
opportunity
які,
to set some
на мою
processes
думку, могли б
right
здаватися мені
that
або колегам
I or my colleagues
такими, які неправильно організовані.
might
Це я маю на увазі
perceive
роботу
as
апарату суду.
badly organized, and I mean the operation of the
А
staff of the
скажіть, будь
court.
ласка, а на ваше
It
переконання,
is clear,
які,
thank you.
ну, такі заслуги або
What
ваші
are
якийсь
the
досвід вам вдалося обратися спочатку
achievements
заступником, потім головою
or
суду,
what
фактично, майже
experience
коли ви
did you have
прийшли
when you were
ну, через
elected a
якийсь
deputy head
другий
of the
би був
court and then
призначений?
the president of the court just a year
Щодо
after your
посади
appointment?
заступника,
As for the position of the
це була
deputy
ініціатива
president,
серед
i-
колективу голови
the
суду. Йому,
uh,
напевно, здалось, що я
president of
ініціативна.
the court and the staff
Ну, можу сказати, що
initiated
оскільки я працювала в
my
апараті, у мене
candidacy.
був
I
досвід
worked for the court staff and I had the
саме
experience
як правильно організувати
of
роботу апарату. І
running
на той момент це було
the
дуже актуально, і тому була
administrative
запропонована моя
operation of the
кандидатура
court, and this
на
skill
посаду
was
заступника.
relevant.
І
Therefore, I was
попереднього
proposed for the
заступника
position of
закінчив
the deputy
повноваження,
president.
так
The
колеги
previous deputy's
проголосували
term
за
had
нього.
expired,
Щодо
so the
посади
colleagues had
голови,
voted for me. As for the
я не можу
position of
сказати,
the
що якось
president,
я
I wouldn't
вирізнилася чи
say
вижила
that
серед всіх колег.
I
Просто так склалася ситуація,
distinguished
що
myself
більшість
amongst
колег,
my
які
colleagues,
працюють
but
там
most of
довше,
the colleagues
вони були
who
без
worked for
повноважень.
the court
А
longer did
серед
not have
3
the
колег, які були з повноваженнями,
powers, and of the 3 who
вибрали
had
мене.
the appointment, I was the
Так
one to be
склалося.
selected. It
Добре, дякую.
so happened. Fine, thank you.
Також до
If
питання
I may
до квартири,
revert
яку ви
to the question
придбали
of
в
the
місті Шостка,
apartment that
в
you
зв'язку
had
з тим,
bought in
напевно, що ви там
Shostka,
проживаєте.
because
Я
that's
правильно
where you're
розумію, рік
living.
придбання – це
The
2019 рік, 60 метрів квадратних.
apartment was bought in 2019 and a 60 square meter apartment.
Дивіться, в чому
Look,
суть питання?
the nature of my
Ви
question
призначаєтесь в
is
16-му році,
so
в
in
19-му
2016 you appointed and you buy the apartment in 2019.
на оренді були,
All the time, were you
що
leasing?
саме вас спонукало в
And what
19-му році саме
urged you
придбати квартиру?
to buy an apartment in
Коли я була
2019?
лише призначена в
When I
Шосткінський
was
суд,
just appointed to Shostka
я взагалі не
Court,
мала де проживати.
I
Я
did not have a
орендувала
place to
собі
stay.
житло, я
I
повідомляла
rented a place.
адресу,
I
розмір
did
оплати.
report my
Певний
address
час
and
я не знала, чи
the
взагалі
lease I was paying
буде моє
for a
життя
time.
далі
I didn't
пов'язане з
know
Шосткою.
whether my
Тому що
life
я
would be
приїхала з
connected with
Києва,
Shostka. I
і
arrived from
почуття було,
Kyiv
що мені
and I
хочеться
was
змінити
feeling
місце
that
на
I
більш
wanted to
місто, на
change.
більш
my place of living for a bigger city, but after a while I realized that I was content with the team, with the city and the work, and it provided space for development. It was very important for me not to have 2 or 3 cases to consider a month, but keep developing professionally. So I decided that the life dictates that I should stay in Shostka for an indefinite period, so I bought a place for me. Fine. How would you describe this property? And I'm asking you because the price of the apartment is $7,000. The market value seems consistent with the region, but there are higher and lower prices. So if you could please elaborate. The apartment is in a house built in 1886. The key problem is that it is on the 5th floor. It was my first apartment. I didn't realize it was a problem because then I had to pay my own money to repair the roof. Indeed, some apartments went at a lower price, but they were unlivable. You could buy a 3-roomed apartment for 6,000, but they were not livable. Some other apartments went at a higher price, but it's Soviet time renovation, but it's livable. And I was prepared to pay 8,000 at the max, and it was between 6 to 8,000. Thank you. In this context, let me ask you the following question. Analyze the declaration since 2016, your appointment, until 2019. I could see that you made enough income for surely in a year to buy the apartment. Still, from 16 to 19, you're not declaring any cash, but after 19, I can see that you are beginning to declare some bank deposits. Why is it? Before 2019, did you spend all and starting 19, you started saving? These were different earnings. When I started work in 2017, I annually earned 12,800, so I couldn't really save up, although I could make ends meet. And the next year it was a bit more, 14 plus, and then after the Constitutional Court ruling, when the courts who were rated equally if they completed the assessment or not, and my salary changed, so I was in a position to save and buy the apartment. Although I bought the apartment before the decision, I don't remember so precisely. I remember planning, I remember putting aside money and putting aside some money to make the end go by. I had the money to buy the apartment, and the price was okay, and the apartment was okay. It was close to my workplace.
Thank you. Yes, it is so. I remember those years and the decision of the Constitutional Court. All those who are judges would remember that decision as well. Okay, thank you. As I analyze your declaration, I saw that you had some small amount of shares and you had them prior to 2019, right? Can you give us any comments about how you acquired them? Maybe that was, very, very old. Yes, it's true. My parents purchased those shares in 1990 something in my name. I think it was 1995 or 96. I was a minor then. It was a non-profit company. They never paid any dividends, and since that time, the enterprise was in the permanent state of bankruptcy. Finally, 2019, it went bankrupt. After that, I stopped declaring those shares. In that respect, could you alienate those shares in any way. No, I could not, because the company for a long time was in the process of getting bankrupt. I even, as I was already a judge, I talked to the arbitration manager, asking him whether I could get rid of those shares, but he then explained to me that it was impossible as long as it was. It was impossible at that time, so I just waited for the bankruptcy of that enterprise. Thank you. In other words, you didn't have to fill any legal deeds in that chapter of the declaration. No, I never alienated them. And one more question. Well, basically, you have explained it in your comments for the public council, but it would be important for an external observer. The civil society or the NGOs, they turn to us suggesting that you have rendered decisions of the court in the period where you were not working there while you were away. Well, you mean those decisions that were mentioned in the letter that I've received, right? Yes. Well, I have provided my explanations. Of the list of those decisions that were mentioned there, only 3 of the decisions were really signed by me. I cannot say that they were rendered, but they were signed by me on the date when I was really away on vacation. That is between March 27, the 8th of March, and the 6th of April. Let me explain what these procedural documents were. These were the decisions that civil proceedings were to be opened. Those cases had come to my office earlier, before I went away on vacation, and we sent requests as regards the place of registration of the plaintiff, and we were waiting for the final responses. And when I was away on vacation, we received the responses, but I had told my assistant that if the registration place of the defendant would be confirmed, she should draft the decisions on initiating the proceedings. And that's what she did. When you register a document within the system, or a draft document, it automatically assigns the date on which this paper was developed. And when this document becomes no longer a draft but the original, you have to change the date manually. I came back after my vacation, I signed those decisions, I read them, but I made a mistake when I did not change the date. And there was 3 of such procedural documents during my period of vacation. As regards the 3rd of August, there were 8 or 9 decisions. On that date, I was called off from my vacation. I was called back to my office because there were several criminal proceedings on an intended murder, and we had to make a decision about pre-trial detention of the person. On that date, 2 decisions were made at both panels, and it was my normal working day. That's why I rendered a number of other judicial decisions that were required. So that information, as regards the 3rd of August, this information is not true, assuming that it was a mistake. Thank you. Colleagues, would you have any more questions? I have no more questions. Yes, please, Oleg. Good afternoon, member of Commission Koliush. Tell me, please, what cases have you mostly worked with while you administered justice? I understand that you no longer have the authority. I worked with all categories of cases that would come to the court. Criminal cases, how many? Roughly. Well, in general, after those 4 years and 8 months, I had 6.5 thousand cases. How many of them were criminal? Many. I can tell you many. I was not ready to give you the exact figures. Some of them I heard as an investigative judge. Others as where I rendered the decisions on the merits. Unfortunately, I cannot. Well, I don't remember those figures, just the general number of them. But you were an investigative judge. Yes, almost at once. There were just 3 of us in the court. 3 judges, I mean, almost during all the time while I performed my work. So we work with all kinds of cases, not only the ones where we had the jurisdiction, but where the other courts around us, had the jurisdiction for those cases, but they couldn't form any panels. And I have a lot of experience in collegiate consideration of cases. Tell me, please, within the Article 19 of pretrial investigations, according to the Code of Criminal Proceedings, is the time included during which you are to study the cases? No, the time during which you and the defense have to study the cases, this is not within the time limit, and the law does not say that the prosecutor is to have special period of time to study the documents provided by the defense. Don't you think that this is the violation of the principle of equal rights? Well, it is possibly so, but the legislators have decided that it should be this way. I even once had to close down criminal proceedings as regards, for example, the delayed time of proceedings, the length of proceedings. And it was about a drugs case, and I was very sorry about that. Member of the Commission, Melnick. Well, as the subject of the special meeting is not only finding out the issues about the way of your life, but also the knowledge in terms of the cases you would work with at the High Anti-Corruption Court, and that's clearly a provision of the anti-corruption laws. Tell me, please, how can one differentiate between an illegal present, receiving an illegal gift, which is mentioned in the Code of Administrative Justice, and a gift for which there would be criminal liability, according to the value of the gift? The value of the gift, in other words, if I receive a gift for performing my office duties, but the value of this gift is, for example, let's say 1,000 hryvnias, so then my actions would be qualified as a corruption-related case, but not as a fact of corruption? No. Persons who hold certain positions, they don't have the right to receive any gifts related to their professional activities of any size. In other words, your answer to the first question was not very correct. Yes, I didn't understand it correctly. Fine. Then, tell me, please. Okay, with account of the question I've already asked and the answer you've given, let's imagine a situation. A judge who has rendered a lawful, legal, and a fair decision receives as a sign of gratitude for wonderful work from one of the parties, let's say a picture that has been made by that person as a gift. It's a piece of art, as a sign of gratitude for a well-performed job. The judge would accept that picture. How would you qualify those actions? Would that be a violation of ethical norms? Would that be a violation related to corruption, for which there would be liability according to the Code of Administrative Offenses, or is that a crime? It is a crime. According to what grounds and what signs? Sign? Do you mean an article? Why is that a crime? Well, these are actions related to one's professional performing one's professional work. I may not have proper vocabulary in this area because I don't really have much knowledge, but I will try to study. I do it well. That's why I can make mistakes now, and maybe Well, I'm not claiming that I'm a high-level professional now. I still believe that I think it's a corruption-related case because a judge does not have the right to receive any gifts related to performing his or her professional duties. I don't know whether I'm correct or not. Can one use the fact that the value of the gift is too low in this situation, in view of the fact that the value, well, nobody knows what its value of that picture is. Maybe that's something that doesn't have any value at all, and basically such actions of a judge possibly are not dangerous for the society. Article 368 of the Criminal Code provides an understanding of the low value, but it cannot be used. Even if it costs 2 or 3 hryvnias, such an action cannot be considered of a low level. How can you explain that? Why? Because a judge has no right, according to the law, to receive any gifts for performing one's professional duties. I understand. Thank you. Please, Vitaly. Good afternoon, Tetiana. Vitaly Hanseluk. I'm looking at your biography, your CV, and among the documents in education, I see 2 diplomas, the bachelor's degree of 2006, the Master of Law of 2007, and one more earlier diploma of 2004. Can you please explain what kind of diploma that was? Yes, I studied at the Interregional Academy for Public Administration Management for 3 years, and first I received a diploma of a junior specialist. Then I had a contract with educational establishment. I received the education of a bachelor, and then I continued studying, and I received the diploma of a master. Thank you. Colleagues, any more questions? Member of Commission Sabotage. My question is, between December of 14 and February of 2015, you were an assistant to a judge of the Court of Appeal. Yes, I don't remember. Why such a short period of time? No, the period there was... You mean of the president of the court? You were an assistant to the court president. Yes, I was for a short period of time an assistant to the president because when I left that position of the assistant judge, I planned to work as a staff worker of the court to improve my knowledge of the work of the staff, and the pay was quite different. I remember that there were some problems about holding that position. Either there was a problem with the vacancy or some other documents were missing. I don't remember that, and I really performed the duties of the assistant to the president of the court, but for a brief period of time. Well, in fact, we're trying to understand why, because later, as you remember, there was quite some special events that took place in the summer of 2015. At that time, you no longer work there. What was your position at that time at the Court of Appeal? Would you remember in the summer of 2015? Well, I was an assistant judge. Well, I'm talking about the searches that were taking place at that time. Well, I don't remember whether I was the deputy chief of staff at that time, or whether I was still an assistant president of the court. Maybe I was the assistant president of the court. Most probably because my office was also searched. Do you remember what that story ended up with? Well, in my presence, it was not yet over. Well, they never summoned you any longer, right? Well, so you would know that, all right? And the last question, if you allow me. You are a judge with a 5-year period of authority. Now, what did you do when those 5 years of your competence were over? I helped, and I keep helping my colleagues. Do you live with your parents now in their house, or do you continue living? No. have not lived with my parents since 2003, and that's really so. Now I live in the city of Shostka. So where you live, where the court is, and you go to work every day. I go to work there. Thank you. Colleagues, any more questions? I'd like to ask you a question. Tell me, please, have you ever felt in the position of a judge any external pressure related to your professional work? Well, perhaps only not so much of the public, but of certain persons who would come to the courthouse and who did not behave ethically. I couldn't call it pressure. It was just certain problems we could face in order to have a normal court hearing. But pressure as pressure that can influence my decision-making, no, luckily I didn't have such situations. Thank you. The High Anti-Corruption Court hears quite serious cases, and theoretically such pressure is possible there. And that was the reason why I'm asking you, what do you think? How can you cope with that if such facts take place? What would allow you to confront this kind of pressure? Well, I cannot even imagine how one can exert pressure against me, upon me. What sides of my nature one can use. As regards financial issues, well, I cannot say that I'm indifferent, but this is not how one can exert pressure upon me. Some kind of dirty stories in my past, I don't have that. How one can blackmail me, how one can, do that with threats of violence. Well, there are law enforcement authorities who can investigate those things, and there are all sorts of kind of safety measures for the judges who hear risky cases. So I cannot even imagine this kind of pressure in my life. Thank you. Colleagues, any more questions for the members of the Commission? Dear members of the Public Council of International Experts, maybe you have additional questions?
Yes, if you allow me, Mr. Chairman, I have one question. One of the things that we have to look at is professional competence. That's also in the law that the PCIe has to investigate whether a candidate has professional competence. You have just stated that you do have criminal law experience, but also that you come from a reasonably small court, as you do not have any experience in handling larger corruption cases. And of course, what can be predicted is that in the near future, Ukraine will be confronted with quite a few larger corruption cases that, because of the flow of money that we hope will come into Ukraine to support Ukraine, there may be larger, very international oriented corruption cases for which wherefore also, let's say, complex structures will be used in order to hide the funds at stake. If I listen to you, I would think that you have quite a few things to learn before you would be able to understand and judge such kind of difficult structures or financial things that you have never seen before in your life. How would you deal with this, and how do you make sure that when you would be a judge in the High Anti-Corruption Court, you would be able to deal with those cases efficiently, and that you would understand what would be happening so that you could take a decent decision?
Звичайно, я буду удосконалювати свої знання спочатку
I will keep improving myself, first in theory by reading the case law, the literature. I do admit that every trial in a criminal case often takes time, and over this time there is much information that you can grasp. Moreover, the prosecution and the defense are professionals, and they will also present their theories of the case and will be able to assess them comprehensively and shape my vision. I realize that I will need to learn. I'm not claiming to have the experience. You cannot gain this kind of judicial experience if you hadn't sat on such cases as judge. I know that I'm good at learning, I'm dedicated to learning, and I will continue learning at whatever position I am, and I hope I will succeed.
I hope so too. Have my colleagues questions? No, thank you. Mr. Chairman, back to you.
Дякую. Тетяна Володимирівна, у вас є можливість звернутися до комісії,
Tetiana
до Прем'єра,
Volodymyryvna,
якщо є
you can address
таке
the
бажання.
Commission, the PCIE, if you would like to. I would like to thank you for your questions, and I hope I've been able to provide the answers to all of them, and I'm grateful to you. Thank you for your participation. All the best. Goodbye. We are now announcing a recess.